Hello, everybody. It gives us really great pleasure to introduce the 2023 IBFD Yearbook on taxpayers' rights. This is produced by the Observatory on the Protection of Taxpayers' Rights based here at the IBFD. This is now the 7th year that we have produced an annual yearbook. We started in 2017, but the work of the Observatory really goes back to the IFA Basel Congress, which was in 2015, and the original collection of information was in 2014. So putting it all together, it's essentially 10 years that we have now been examining the protection of taxpayers' rights through the safeguarding of minimum standards and best practices. As this is the 10th year, for the year ahead, we have been reviewing the minimum standards and best practices and developing some new minimum standards and best practices in the light of the data collected over the last 10 years, including, for example, a whole new set of standards in relation to artificial intelligence. And that will be reflected in next year's report, but we have designed those new minimum standards and best practices so that they are additions to the existing ones, so it will still be possible to make comparisons between the practice in previous years and the practice in future years, and therefore we can determine to what extent there has been an improvement or a negative trend with regard to the respect for those standards. Now, perhaps, Pasquale, you'd explain about the production of the report.
Yeah, I think it's, thanks very much, Philip, and a warm welcome from me too. The production process is rather complex, but also rather stable, because at the end of the day, what we really want to achieve is to secure some stability in the monitoring of practices. So we have set up a beautiful team which involves our two scientific coordinators, Alessandro Turin and Sam van der Vlucht, and the contributors that have assembled all the materials that has come from the 55 countries that have reported developments in the area of protection of taxpayers' rights. And I would like to particularly thank the Giovanni Consolo, Philip de Belva, Ivan Lazarov, Clara Moreira, Stefano Ronco, and Marina Serrat, who have helped us in bringing all this together and processing the information that we have received from those countries and correspondence. Our goal, as I have mentioned, is to support empirical research in legal science and in tax law in connection with taxpayers' rights. So this is about the process that we have set in action, and as Philip has indicated, there will be some changes next year. Now it's interesting also to consider that we want to present some highlights from 2023 from the report that is now being made publicly available. We have thought about selecting some issues from around the world. And we thought this year about clustering those developments by looking at the positive developments and the negative developments. So that will give you a better feeling of what has happened in 2023. And so we'll start with the analysis of positive developments, and then we will continue with the negative developments. Of course, when we talk about a positive development, we regard as such something that strengthens the effective protection of taxpayers' rights. And that is something which, could be analyzed from different perspectives, because there can be specific improvements. We're talking about the positive side, and there can be also some more structured ones. And I think that we should start by an interesting development that just happened at the very end of 2023 with the reform of the Taxpayers' Bill of Rights in Italy. The Taxpayer Bill of Rights has been undergoing some substantial reform and has turned into an instrument for implementing all constitutional principles, the principles of European Union law, and the related pattern of the European Convention on Human Rights. So this basically shows that a general law such as the Taxpayers' Bill of Rights can secure a comprehensive protection of taxpayers' rights, also by giving constitutional principles and supranational law principles and international law principles a more concrete dimension in the field of taxation. So I think that it is important to mark this change in Italy, which is certainly a positive change, goes in the right direction, and might be also interesting for other countries to consider. When it comes to the specific issues that we have selected for you, I think it's interesting to talk about what I call the Orde van Vlaamse-Bali's legacy. The Orde van Vlaamse-Bali's is a judgment from December 2022 by the Court of Justice of the European Union that has stressed the importance of an effective data protection. As you know, in the European Union, we consider particularly important to secure effective levels of protection. So this is a 2022 judgment, but the reason to mention about it in the 2023 report is that we gathered evidence from the reporting countries. We gathered this evidence that indicates that at least in some countries, and in particular I would like to refer to Bulgaria, Lithuania, Slovenia, and Spain, there have been there has been some strengthening of the protection of taxpayers' rights. Now, Philip and I think that this is a year that we should, in which we have recorded more positive developments than negative developments. And so this is very much encouraging also that the so-called dialogue between the supranational court of the European Union and the national court goes hand in hand with a sort of aligned development. So this is on, a stronger data protection, so something that we can have from the European Union. And I think that from Europe, we also have some other interesting positive developments which relate to what we generally call naming and shaming. Now, naming and shaming is something that Philip and I, since the Basel Congress, have indicated as a very negative phenomenon that we have 10 years ago indicated as a pillory. I still remember that we presented a slide with a pillory in the middle of the main square of a village in the Middle Ages, and naming and shaming still exists. But the interesting development that could be recorded is from Spain, and this time at the beginning of 2023, the Spanish Supreme Court has indicated that even though the law allows for publication of the names of the non-compliant taxpayers, that publication should be made only when there is a final judicial decision. So this is very reassuring, because even though we consider naming and shaming very negatively, then at least this naming and shaming takes place after there has been a judicial thorough review. And this allows us also to mention that some related developments have occurred at the level of the European Court of Human Rights in the LB case, which is also addressing issues which are connected with this topic and related also to the area of whistleblowing. Now, I think that this is something which, from our perspective, could be indicated as positive development that has occurred in 2023, but there is more that Philip might want to share, because we have selected also some other positive developments. Philip?
Yes, if I may, I'd like to highlight 4 other positive developments that come out from the 2023 report. Firstly, and this is really a development of the use of online systems during COVID, a greater development of online access to revenue authorities, making it easier for taxpayers to carry out their compliance obligations, linked also with a realization that there are some taxpayers who, for various reasons, disabilities, distance, find difficulty using online access, and a noticeable growth in the arrangements in several countries for those who have difficulties of accessing the revenue authorities to be given assistance in doing so. Linked with that is also a greater availability of legal information about the tax system available online. Of course, it's critical that taxpayers, in order to be able to protect their rights, understand what the tax law is, and online systems are providing for that. A second development that's noticeable in a number of countries is a tendency towards a greater leniency and a reduction in the imposition of criminal penalties, particularly having regard to the principle of proportionality. And while we're talking about criminal procedures, the effect of the European Court of Human Rights decision in AMB versus Norway is still being worked through in a number of countries in terms of the ne bis in idem principle, the principle that someone should not be liable to 2 or more penalties, proceedings as a result of the same conduct. And as a result of that, a number of countries have also been examining their systems for integrating administrative penalties and criminal penalties. Finally, a more general development that we've noticed, and again positive one, has been a growth in the use of public consultation before there are changes to tax laws in a number of countries. And we regard it important as part of taxation on the basis of representation that there should be this positive public consultation before tax laws are changed. That's a review of some of the positive changes, and overall I think our view is that this has been a year where the positive changes have been more than the negative ones, but we shouldn't disregard the fact that there have been some negative movements in some countries. So perhaps to kick off with that, Pasquale, you have some negative points.
Yeah, I think that it's always difficult to understand whether in a situation of conflict between the protection of fundamental rights and the protection of individuals and the protection of the right of the state to effectively levy taxes, whether some kind of balance in favor of the latter interest is to be regarded negatively. But still, to some extent, what we have always indicated as the right way forward is that there is a need for balancing those 2 rights, and in under no circumstances the fundamental rights of taxpayers should be put in danger. So yes, we need to secure an effective protection of the state, of the right of the state, to secure an effective, to have an effective fiscal control or an effective revenue collection. But at the same time, it's also important to do that in a way that respects the fundamental rights. With politicians, sometimes it is rather challenging because the public, the public role could, to some extent, make some issues more popular for the country, and perhaps it's a more delicate balance. Striking the balance might be more difficult. Interestingly, the South African Constitutional Court in 2023 has reached a majority decision by 1 vote, actually, in the Zuma case, indicating that the confidentiality issues related to the former South African President Zuma should not take priority over the interest of the collective South African people. And that is one example. As I said, it's an area which is rather delicate. And indeed, I think that even if the predominance of the interest of the collective interest is perhaps something which could be regarded as negative, it is still good to see that there is serious discussion before deciding whether that predominance should really take place. We are a little bit more concerned in respect of another development which came from Mexico. And I must say that when Philip and I looked at the Mexican system back in 2015, we even came out explicitly with praise for the Mexican system, for the protocol at that time, and the interpretation and application and the protection of rights. But we have noticed that in 2023, there has been a judgment from the Constitutional Court of Mexico that has concluded that the need for a judicial authorization for tax authorities to access bank information is to be regarded as unconstitutional. So the interesting point for us is the legislator had set that standard, and then now that standard, which we don't think is to some extent threatening a fair balance of rights, has been regarded as unconstitutional. So that's a step back. That is something which should not be left to the remit of the legislator. But when the legislator had decided to stick to that standard, the fact that it's regarded as unconstitutional is a bit problematic. And the last point that I would like to mention is that we have noticed that there has been recognition of discretionary powers of tax authorities in Germany as to the right to access cooperative compliance. Now, certainly cooperative compliance is a delicate area. However, we tend to be a bit suspicious when it comes to giving tax authority discretionary powers. As you know, under international law, in the presence of discretionary powers, then arbitrary exercise is always around. So there is always a bit of suspicion in that respect. So as Philip indicated, fortunately, there have been more positive developments than negative developments. Perhaps let us also say that perhaps this is also due to the fact that with our Observatory on the Protection of Taxpayers' Rights, there has been a growing global awareness of what the best practices and minimum standards are. But let's see what now Philip has to share on the negative points.
Well, really just one negative point to highlight, and that is we have been emphasizing and drawing attention to the fact that since 2015, pressure has been put on countries, partly through the Forum on Exchange of Information, to remove protections for taxpayers who are the subject of exchange of information by removing any legal rights of those taxpayers to be informed of the exchange. And unfortunately, this year, a negative trend has continued in that respect. So, for example, Botswana, Honduras, they have both seen changes that deprived taxpayers of notification before there was exchange of information. I think as a very final summarizing comment, Appendix A to the report is always very interesting because it contains a green column and a red column. Green are positive developments towards the respect for the standards, and red are movements away from that. If you examine the report for this year, you will see that there are more entries in the green column. It's not scientific, but it generally supports a movement towards the protection of taxpayers' rights. The movements in the red column have largely been in the area of confidentiality, leaks, disclosures of information, and cross-border procedures, particularly the point I just made about not informing taxpayers in advance. So overall, a year where there have been, as Appendix A shows, some positive developments, but sadly also some negative developments, but generally more positive than negative. Thank you very much indeed for listening to us.
Thank you.